This is a time set for oral argument in our case number CV18-0744 in the matter of James R. Baum and Myra R. Baum Trust et al. Counsel, each side has 20 minutes for oral argument. If appellants wish to, or if the parties wish to split their time in any respect, that's all up to you. And if appellants wish to reserve a portion of their time for rebuttal, or appellees with respect to the cross appeal, you're free to do that, but that will come out of your 20 minutes, and you need to keep track of your own time at the podium clock. Out of respect for counsel and so that arguments aren't interrupted, I would ask, and to avoid embarrassment, I would ask that those in attendance make sure their phones are off so the proceedings aren't interrupted. We have reviewed the record. We've reviewed your written briefs. We've conferenced the case. We'd encourage you to keep that in mind as you present oral argument. And please, if you would, for a variety of reasons, including that the proceedings are being recorded, start when you proceed by telling us your name and the party that you represent. With that, we'll look to appellants.
Thank you, Your Honors. May it please the Court. My name's Al Arpad. I represent Myra Baum only. Mark Anderson here represents Myra Baum's children, the other four parties. The parties' positions are essentially identical on all issues, so for convenience and to avoid delay, I will be doing the arguing unless you have a question I can't answer about Myra's children, and that's why Mr. Anderson's here. I'd like to reserve at least say 4 minutes for rebuttal if I can, because it is a very complicated case and I'm not really even sure what direction this argument is going to go in. We're here in the unusual position of an appeal from an interlocutory discovery order that was certified and the associated attorney fee award, which were certified under Rule 54B, in my view erroneously. I think I've made that clear at multiple points in the proceedings, both in the trial court and in an early motion here. Because we're here, I get to argue whatever Your Honors want to argue, whether it's the merits or whether it's Rule 54B or whatever. From Myra's children's perspective, they are here mainly to argue about the unfairness of the attorney fee award, and they are not particularly focused on getting back in the litigation. So to the extent they are arguing about the merits of why they were allowed to participate in the litigation in the first place, it's mainly to show that their position wasn't unreasonable. They've had quite enough of this at this point and probably don't want to get back in. So that's not really the focus of their argument.
Is the issue of the insurance policies, which were the subject of the two subpoenas, still viable?
Well, what's going on in front of the trial court right now, the 2017 petition to discharge Ms. Holt is still in front of the court and has been sitting for quite a while. There have been a lot of other proceedings going on. Myra has since filed, one of them was mentioned in the briefing and one of them wasn't because it was filed a little later. Myra has since filed a petition that very specifically and clearly goes after those issues, that essentially she was deprived of a large portion of her community property by transferring life insurance policies into those trusts, even if on the face of those trusts she clearly wouldn't have an interest under the terms of the trusts. That is all still in front of the trial court. And
has she received those? Has she received the documents that this appeal concerns?
There has been no further discovery. The court is currently trying to decide what to do with those petitions, and in fact, it all revolves around whether this settlement agreement is enforceable, which again is another issue that's before the probate court, not before this court. And so in order to decide anything in this court, you have to somehow segregate that out and not pre-decide it, which of course is one of the difficulties under Rule 54B.
So are you suggesting that we shouldn't be here today?
Yes, I have suggested that several times. I would have preferred to save the money and have this be dismissed out early because I think that's going to be the end result one way or the other, but here we are. I don't think this is a 54B judgment. It talks about all kinds of things that are still ongoing in the trial court. To the extent it talks about something that could have been the subject of a 54B judgment, it's not clear that that's what judgment is being granted on.
Counsel, let me ask you on the procedural ground, and then I would like to get to the substance. If the court elected to treat this as a special action, is that in the court's discretion?
If you're asking me, would I file a special action 4 years later?
Different question. Can the court, if the court has doubt about appellate jurisdiction, because again, if we lack appellate jurisdiction, whatever we do is void. If the court instead treated timely notices of appeal where there was doubt or where appellate jurisdiction was lacking as a special action, would that resolve the jurisdictional issue?
Well, the court's special action jurisdiction is pretty broad, so yes, the court would have jurisdiction if the court sees something that's suitable for a special action here and wants to decide it. Whether that's a great idea, my client's very clear. She would like to have that discovery order turned around.
Your paper could not be more clear, papers could not be more clear that you've not argued that, but
Okay.
I just want to, now, having said that, I would like to have you address the merits if this court does have jurisdiction.
One other thing, and this was reminded to me by my trial counsel, because I'm so focused on Rule 54B as an appellate lawyer, I maybe didn't make it clear enough that, in fact, if you accept the opposing party's argument that, no, this is only a judgment against the children, and it has nothing whatsoever to do with Myra, and she's not even an aggrieved party here, that accomplishes 90% of what Myra expects to accomplish out of this appeal. Because her main interest, the children's main interest is to turn around this fee award. Her main interest is to prevent herself from being precluded in the ongoing proceedings from all sorts of things that are mentioned, from attacking the settlement agreement, from getting discovery. She doesn't want those things to become final in the middle of litigation for practical purposes. That's a problem for her. And there are reasons to say that's what the court intended to do. I mean, the probate court said that's what it intended to do, was enter a judgment that was mainly against the children. Doesn't really look like one, but that's what the probate court said it intended to do. And the court denied Myra retroactively, struck her joinder, so she's not participating in the proceedings as a technical matter. So Myra can win by losing on those issues. Her main goal is to just not be precluded from finishing out her case by whatever the result is in this case. To get to the merits, I want to highlight the overall unfairness to Myra's kids of this. They were brought into this by Deborah Holt. They were named in a series of things as interested parties. And I think if you look at the statute, they clearly are interested parties. And they're still interested parties today, even if you assume that they don't have anything other than a revocable interest in any trust property. Now, that's not entirely true, because there's at least one insurance policy in which they admittedly have some kind of an interest. But even if you look at just the joint trust and say that's a revocable trust and there are revocable beneficiaries and therefore they're not allowed to pursue discovery, they're still interested parties. And they're still interested parties who filed a response that mainly didn't request any substantive relief, that really only said, gee, we need to look at the papers and decide what we think about this. That's what they did. And as punishment for that, they got kicked out by the same person who brought them into the litigation and fined $50,000. That's a lot of money to spend on a discovery motion, and it's a lot of money to fine someone. I'm not a criminal practitioner. I looked this up before the hearing, but I believe the highest fine you can get for a misdemeanor is about $2,500. So this is felony level unreasonableness that we're talking about here. $50,000 worth of trying to get some discovery in a case where somebody else named you as a party. Unless you have questions, I think that's most of what I mean, they've taken a very common sense perspective on this. The other side has complained because they didn't sufficiently address all the cases he cited about 14-10-603, and we've said that some of those cases do say that. We think there are a lot of policy reasons why that question is more complicated, partly because what that statute's all about is the trustor's control over the trust, and Myra doesn't, in fact, have control over the trust. Somebody else currently has control over their trust, and Myra and her kids would both like to get discovery. And I apologize, I have a cold, so I'm...
Counsel, let me ask you, with respect to the control over the trust, she was a co-trustee in 2016, right, when the first subpoena issued?
Yes, that's correct.
So that at some point in time, and it's in the record, that ceased to be the case. But at that point, she, as a co-trustee, would she have had a right to access to the
I think she had an
documents?
I mean, one of the things she's actually asking for is access to the records of her own accountant who she felt was not cooperating with her. It boggles my mind that you would deny discovery to a trustee to try and find out what her own accountant was up to. Again, the rationale of that was that she'd settle all claims that could ever happen and that therefore she's not entitled to discover anything. I don't think that's an appropriate rationale, but...
And can I, whatever that settlement did or did not do, and that clearly is not in front of us. I can't be more plain on that.
I'm very glad to hear you say that.
Well, she remained on as a co-trustee.
She remained on as a co-trustee in 2016 and on into 2017, at which point there were proceedings and
Right.
she was removed. And by the way, she asked for that to be finalized so she could appeal that, and the judge said, no, I won't finalize it.
And that's not in front of us.
That is not in front of you.
Right.
But it just does show there's a tangled web going on down there, and for some reason the court decided to clear its desk on this particular issue and let you sort out what's appealable and what's not appealable, which, by the way, I think is a policy argument for you not to blue pencil judgments. When someone sends you a 54B judgment, I would urge you not to search for appealable things if it doesn't on its face appear to be appealable.
We take cases as we find them.
I appreciate that, Your Honor. It sounds like the court has... There's another odd issue which, frankly, the world could probably use some guidance on, and that is the question of whether we really should have objected to the 54B format under Rule 58 before the form of judgment was entered. That was actually the reason the judge said she didn't want to hear from us. I've never heard that in my life. If that's true, I would certainly like to see it in a published opinion, because I think everybody should know that.
What is that again?
Essentially, that rule, if you don't file an objection to a form of judgment within 5 days under Rule 58, that you have then waived the right to file a Rule 59 motion on that issue. I don't think that's the law.
On the merits or on the 54B issue?
Well, on the 54B issue in this case, that was the only issue we filed a Rule 59 motion on. So that's what it was in this case. But if that is in fact the effect of Rule 58, is that it causes you to waive things that you should have been able to raise in a Rule 59 or 60 motion, this court has an interesting job to decide what sorts of issues that would be. I don't think that's the law, and it would be nice to know that for sure. The 2016 discovery ruling, which is the one that really aggrieves Myra, partly because it seems to cement this settlement issue, which is not final below, but also partly because it denied her discovery completely rather than saying, okay, I think you're only... And the Brown case, which was actually cited by the other side, gives a really nice example where the court went through and said, okay, the court could deny some of this discovery because arguably it was over the top and some of it, was maybe work product, but they're entitled to this other part. And so if you're going to reach the 2016 and 2018 rulings, I would ask you to try to set some kind of reasonable standard. Myra Baum can't be entitled to zero discovery about the trust of which she is the settlor, was at the time the trustee, and continues to be the main beneficiary through which everything passes on her side of the family. Unless you have questions, I'll reserve the rest of my time. It seems like you are clear on, I think we've briefed an awful lot of things, but I don't know that I need to get into them unless you have questions about them.
Not at this time, counsel. Thank you.
Thank you, Your Honor.
Counsel for Appellee's Cross-Appellee.
Good morning. My name is Tom Asimo. I represent Deborah Holt in various capacities of those irrevocable trusts that we've been talking about. And I apologize that I don't have quite the joie de vivre at the Court of Appeals, because this is my first time in 20 years as a lawyer that I've been in front of the Court of Appeals. couple things that I think need clarification from what Mr. Arpad has told the court. The discovery issue. And I don't want to re-argue this whole thing because that's not why we're here, but the first pleading that was filed in this case was simply, literally, the Monday before Thanksgiving 2012 was to allow my client to get records about those irrevocable trusts that were in the possession of Myra Baum. It's a misnomer where Mr. Arpad says that his client was denied all discovery. You don't get to seek discovery from my client over broad subpoena that the court saw for what it was. Mr. Arpad's client, and it was not Mr. Arpad obviously, but they never did anything to tailor that under Rule 26. Sorry, I'm getting old. My glasses from my eyes versus looking far and looking near.
I thought that by the time this was litigated, Myra had narrowed her subpoena to the accountant to seeking insurance policy documentation.
That's not necessarily true. So she had sought things from back to 2009.
Yeah,
on those
originally.
things. Yes, and she never modified that. She never modified that.
Well,
The filings in front of the Superior Court suggest that she had, and that's what we have.
I've never seen that. I've never seen that on that particular issue. There may have been earlier that she did that, but we settled this in front of Judge Klein in 2014. The subpoena that she served thereafter was to go for records from well before that.
I understand that, but by the time the motion practice was before the court, her filing focused on foreign insurance policies.
That she had that. So before Jim Baum passed away, she signed off on those things, and she had those things in her possession. So under Rule 26B1C, she asked for those things yet again, but those were the things in our initial filing that we had asked to obtain from Myra Baum. She had those things.
Okay, but that's not the ground on which the trial court ruled.
Okay. Coming back to the issue that's before this court was the October 2000, the judgment of June 14th of 2018 pertaining to the kids.
Well,
There are two waves, right?
Yep.
There's the 16 subpoena, just for ease of reference,
Sure.
maybe,
Yeah.
and then a 17 subpoena.
The
Right?
kids subpoena in 17
Yep.
and the moms in 16.
And you're talking about the 17 subpoena, and I
Correct.
think we were talking about the 16.
Okay, and in the 16 subpoena, we objected to that because she already had that stuff in her possession and control, what she had been asking for.
Was that the basis for the court's ruling?
I honestly don't remember, because when I looked at these things, I didn't focus on that particular thing, but because the order that these folks appealed from was about the kids. And so,
Actually, there are two appeals that from 54B. I think the case is, at the risk of oversimplifying it, wildly complicated probate proceeding, is the ruling on the 16 subpoena, the fees, the ruling on the 17 subpoena, the fees, and your costs.
correct. And so with the 16 subpoena, they never tailored that to ask from what they wanted specifically from that accountant, to get it to where they were there.
when you say they, are you speaking of Myra?
Myra. I don't think she did.
Okay.
When she says that, they never specifically identified anything from the October 26th minute entry ruling. When that ruling came out, we filed our motion for a protective order. They responded. There was a reply. The minute entry on October of 2016 came out. I don't recall I'll have to relook at the record, but I don't recall that Ms. Baum narrowly tailored that in any way. They issued the subpoena. It was smacked down. The subpoena that Mr. Anderson's clients then issued and served was substantially similar. Mm-hmm. That too was smacked down, but for a different reason. Myra's was based upon the settlement agreement that she had reached, and I think that was, I can't remember if we've had 4 different judges on it. I can't remember if it was Judge LaBianca that quashed the subpoena that Myra had issued.
She denied Myra's motion to compel.
Correct.
That it didn't matter whether
Correct.
she got the policies or not because she had settled it.
Correct. And she did that, with good reason because the subpoena was so broad. Myra's counsel at that time never tailored that subpoena
Well,
beyond
I think we have a disagreement
Oh,
on the record.
on me? Oh,
on
okay.
that.
That- you
So
may
I
be
think-
right
I
on
think
that.
the record shows that in arguing the matter,
Oh, at the oral argument, you mean,
In the final.
in the filings? Oh, that's right. That was one of their bases for appeal. And that's not a final ruling before this court, actually, as Mr. Arpad said, because when we're talking about that,
that's not a final ruling.
with Judge LaBianca's ruling quashing Myra's subpoena, I don't think ever got to a final ruling in front of this court, to where there was 54B language on it. The one that ever got to a final ruling was for the kids, not for the mom. Maybe I'm wrong on that, but the two things that have been appealed are the June 14th ruling, which is IRE 236.
Of what
And-
year?
18.
Yep. June 14, 2018, the IRE 236, and the October 16, 2018 fee award. Those are the only things that were appealed. The ruling on Miss Baum's subpoena, I don't think was appealed, because it's not final. The only two things that were final were the June 14, 2018 ruling on number 236, and I'll get the other number for you on the October 16, 2018 ruling, but those were the only two things that have been appealed. And those were against the Lotsoff children. When Miss Holt, or Miss Baum, when Miss Baum, her joinder, the only basis of her appeal today was the joinder in, so October 16, 2018 ruling was 263, IRE 2.
Okay, we'll take a look at the judgment.
Okay,
We'll
I'm
do
sorry.
Judgment was 293.
293, or whatever that
Was 293. So I don't think that was before this court, and I didn't think we even necessarily briefed it because it
is.
wasn't
Oh,
a final.
you briefed it,
on
in spades,
on Myra Baum's
like 40 pages worth.
Yeah.
You
on
briefed it.
on Myra Baum's issues.
Take my
Correct.
word for it.
All right. But they didn't. She didn't. That was what Judge LaBianca ruled there was that she was not entitled to those things.
Correct. When she was co-trustee.
Correct. And when she was co-trustee, she had access to those records of her own volition.
Why wasn't she entitled to, as co-trustee, to call up the accountant for the trust and say, give me all you have
She
on
was.
the insurance policy? Excuse me?
She was entitled to do that.
But
Whether she did
apparently-
that or not.
Apparently the accountant, well, apparently your client declined to allow the accountant to respond. Your client objected
We objected
and
to the
moved to
subpoena.
quash.
Yes.
What's the difference between a phone call and a subpoena?
Well, part of what has happened in this case, the reason this has gone on for 7 years, is because at every turn when Myra Baum doesn't get what she wants, we end up coming back again and retooling this. That's what Judge LaBianca kind of was seeing, I'm imagining, because with that ruling of Judge LaBianca that is not before this court with respect to that subpoena, Myra had access to those records in other ways. Under Rule 26, she had alternatives other than a subpoena.
What would that have been?
Under Rule 26, hold on, because I did look at this one. And they're further confusing life for us because they've changed the probate rules again on us.
I guess my point is, since your client objected to the subpoena and moved to quash it, why would your client have allowed Myra to have access to the documents if she had asked for them in a less formal manner?
Because she had asked for those documents from us, not from the accountant. Or she asked for those from the accountant and not from us, and she was a client of the accountant. She could have gone into the accountant's office and asked for what she was entitled to, which was after that settlement.
Then why did your client object? Why did your client move to preclude the accountant from responding to the subpoena?
Because we had already settled those things with Judge Klein, twice.
Wasn't she still a co-trustee at the time? I mean, I guess One way to look at your argument, I'm pretty sure you might not agree with this characterization, is you have a co-trustee wanting what in every objective sense are the co-trustee has a right to, and there's an objection by apparently effectively the service provider to the trust saying no, and then an objection by the co-trustee. I struggle.
But she was asking for things that she was not a benefit. She didn't have an interest in the trust that she was asking for documents.
She was a co-trustee
Of the revocable trust between her and
Correct.
James Baum.
Correct.
She
And
was
the,
asking
and the
for-
subpoena, as I read it, at least included those documents that she had a right to.
And she had them already. But the documents that she was also asking for were regarding an irrevocable trust in which she's not a beneficiary.
And was that the basis for the court's ruling?
I think so, because
Didn't the court deny it across the board?
the court did deny it across the board. Because at the time that she was a co-trustee, the accountings were being done on the trust in which she was a trustee. And I'm confused. I was confused and I'm now not. Where the disconnect is that Myra Baum wanted records with respect to the irrevocable trusts that she has not got an entitlement to, that she's never been a beneficiary of.
Was there any documentation that was, from your perspective, that was responsive to the 16 subpoena that fell within what's called the 1984 joint trust?
So there may have been, but okay, I'm sorry, we have been talking around each other and I didn't even just realize it until now. The reason that there's been this problem with why we're have been so vehemently fighting is there are 5 trusts in which we are, 3 or 4 trusts which we are we are the trustee of, that she is not entitled to any information on because she's not a beneficiary of those trusts. On the joint trust, perhaps, if the court would have said, sure, you can have things from the accountant on the joint trust in which you are a trustee, I don't think that's necessarily a problem. But their subpoena never tailored it that way, and they never came back to the court to say, hey, can you narrow it down to that? After 2014, when we had that settlement conference, the 2 settlement conferences before Judge Klein, that was sort of, it cauterized, I think, Ms. Baum's rights with respect to the irrevocable trusts. The subpoena and the thrust of why Judge LaBianca knocked that out was because with respect to those irrevocable trusts, she gave up those rights both in the settlement conference that we had, the first one, and in the second one. In the second one, her own counsel acknowledged that she had no entitlement to those records. And if you go to the transcript from that second settlement conference, the one that was on June 3rd, 2014, in that transcript, which is in the record, Ms. Baum's own counsel, Stephen Kupaszewski, said, we're not entitled to notice on those, and he was talking about those irrevocable trusts. I am so sorry, I apologize, we've been talking around each other. With the irrevocable trust, she didn't have an entitlement to those records and shouldn't have gotten them. That's why that subpoena was quashed with respect to those assets.
But it was quashed across the board.
Yes. And the other reason that it was quashed, I think, supports under Rule 26. Under 26B1C of the Rules of Civil Procedure, if you can obtain from some other source that if you can obtain from other source that is either more convenient, less burdensome, or less expensive, you do that.
Did your client make that argument?
We did.
And what was the other means that your client suggested that she would not roadblock?
So Ms. Holt or Ms. Baum had access to, there was only one account at Fidelity. Ms. Baum had access to that, inquiry access to that account, which showed all the transactions of the trust.
That wasn't what she sought in the subpoena, though. She sought documents pertaining to the insurance policies.
That she was not entitled to because she was not a beneficiary of the irrevocable trust. I'm
having trouble.
Go ahead, I'm sorry. No, she sought the insurance policies under the irrevocable trust. She sought information on those that she was not entitled to by her own understanding.
Well, wasn't her argument that it wasn't the issue that she wanted to pursue, was the issue of whether indeed those insurance policies should have been in the irrevocable trust, or rather they should be in the joint trust?
She never met her burden to even get to that argument. And as far as those irrevocable trusts that she wanted the insurance policies on, in that June 3rd transcript, her own counsel acknowledged, and I'm at the risk of repeating myself, that she didn't have an entitlement to those.
To those what?
To information about those irrevocable life insurance trusts. So a year earlier, in 2018, she acknowledged that through counsel. In 2014, rather, when we had the settlement conference, where she had counsel at that. They had specifically asked, we had a second settlement conference where she wanted to know specifically about these life insurance policies.
Is this matter that should be before us? If it was a discussion at a settlement conference?
To prove that it occurred, and it wasn't about the settlement itself, but it was to putting the settlement on the record. That, I think, can be proved here through this. It's not privileged that she wanted that acknowledgement. Proving the settlement is not something I think that is privileged, but the settlement, how the sausage got made, I think may be privileged, but the actual
I didn't understand you were speaking of
what
the making of the sausage or the sausage, so to speak.
But coming back to Mr. Arpad did a great job, because we're way far afield from the judgments that were appealed from, which is the kids.
I think his argument, I'm just focusing on his brief now, I think his argument is that if you take as a proposition, if you take as true that the rulings as to the children is a final judgment under 54B, then the prior ruling is the 2016 ruling is an intermediate order which is wrapped into that.
I don't know if I agree with that, because the reason that the kids don't have any standing, the kids of Myra Baum don't have any standing to bring that, is because they're revocable remainder beneficiaries of Myra's survivors trust.
But the reason that the court gave for denying for quashing that subpoena was because they should have. They're just asking what the court denied their mother 2 years before because of the settlement agreement.
I don't think so. I think what the court.
Well, that's kind of what it says.
No, on the June 14, 2018 ruling, which is IRE 236, she specifically says the reason that she's denying the children access to those records is because they're not beneficiaries of the trust. They're not beneficiaries. They are revocable remainder beneficiaries of their mother's survivors trust. They are not beneficiaries of the joint trust. So the reason that she denied them, there is a distinction with a difference here. Mom was denied because of the settlement agreement and the other things that were there. Kids were denied because they had no interest in any of that stuff other than perhaps the guardian policy. And that was never something that they asked for. They didn't even ask for that in their subpoena. So on the June 2018 ruling that we're here in front of the court on, the factual basis of the judicial officer that authored that was why the children were denied was because they were revocable remainder beneficiaries of their mother's survivors trust and didn't have standing to be there.
They were parties at that time.
They were parties for a limited purpose. So it's not briefed in our things, but let me explain why they were given notice. Because there's a guardian life insurance policy. There's one policy that when Myra Baum dies, that policy, my client's a trustee on that trust, along with Jordan Lotzoff, Mr. Anderson's client in his capacity as a trustee of solely that trust, the guardian life insurance policy, part of the discovery and part of the things that Myra has been seeking the entire time was about all of the insurance trusts that my client is the trustee of, that my firm represents her on. Distinguish that from the joint trust and the survivors trust that Myra Baum had with her husband. The irrevocable insurance trust, there's one trust where we gave notice to bind the children, where because of the attack on the assets of that trust by Myra, the Lotzoff children in that trust, when their mother dies, they're vested in that trust. They have an interest there, and we had to give them notice based on that.
And you did?
Yes.
And they filed an objection?
Correct.
And at that point, they were parties?
Only as it pertains to that guardian life insurance.
What I struggle with, though, is it seems to me that the Superior Court denied their request for discovery because they lacked standing to do anything. As
No.
opposed to saying you are a party, you can seek discovery, but it has to be limited in scope. And those are two different things.
Well, let's look at what the definition of an interested party is under Title 14.
And you can do that, although the probate rules talk about them being parties, even if an interested person, I think is the technical term,
Yes.
but in the statute, but the rule talk about when you file a response, that becomes a formal contested proceeding and you're a party. And as a party, you're entitled to seek appropriate discovery, and there can be a debate on what's appropriate, what's not, but I didn't see the Superior Court going down that path. I saw the Superior Court saying what you initially said is you lack standing, you can do nothing.
Yes, because they still, you may have, so this is not red car, blue car, where two parties, one lawsuit, and you're across the V. The difference in a probate trust proceeding is the jurisdiction of the court is in rem. Sometimes it's relevant to, you may have an interest in this part, but you may not have an interest in this part.
It's got to be within the umbrella of the petition that your client filed, which was quite broad.
Correct, but in the petition that we filed is about the irrevocable trust, and they had an interest in solely and only one of those trusts.
So that suggests to me that their discovery might or might not have been proper, but the fact that they sought it wasn't improper.
I don't know if I would agree with that, because
I understand that.
But here's why that's not a distinction. That's a distinction with a difference, because in this, what they wanted to do was get their nose under the tent with regard to the rubric of their stepfather and mother's trust together, the joint trust. The irrevocable trust that they had no interest in, they wanted discovery on those that they had no rights, no entitlement to. The guardian life policy was why, Myra was seeking assets out of.
And counsel, I appreciate it. I think I understand your position. Let me give you a few sentences to wrap up here.
Okay, well, and, I'm out of time. They didn't seek discovery about the islet in which they had an interest at any time in this proceeding. The only thing they sought were things that they were not entitled to. That guardian policy, they never sought discovery on.
Very well. Thank you. Rebuttal argument.
Thank you, Your Honors. I am digesting what I heard there. I'll try to kind of hit some of the high points as I think it affects the decision that you have to make. First of all, it sounds like Your Honors appreciate that Myra's children were not in fact dismissed, and so this isn't a judgment under any circumstances dismissing a party, which is one of the ways that you get to Rule 54B. There aren't any claims, so it didn't dismiss any claims because they didn't make any. They just said we'd like to see some discovery and know what's going on here. In fact, what they alleged when they were arguing about why their discovery was reasonable, they said we're not even accusing Ms. Holt of anything. We'd just like to see if maybe there was a mistake, something got shuffled around if she's handling multiple trusts. And by the way, I think Ms. Holt has taken inconsistent positions about whether the accountant even has information about the other trusts. But Myra, as a client of this accountant, was entitled to see that information and know whether things were shuttling back and forth between those trusts. And it would have been perfectly fine for the court to say that Myra should bear that expense. That Myra should know these things by now. Myra can pay the accountant to go through her files. And if the other side wants to redact some things, then they can pay the accountant to redact things. And if we disagree, we can come back and fight about it. That would have been a perfectly reasonable solution as to the accountant's files. But other than something that's redacted because there's actually some basis to keep it confidential, and I'm not sure I even really buy that in a litigation context, but other than that, Myra's entitled to look at all of the accountant's files. There's just not any plausible basis to say that she should have limited that. If Myra was denied discovery, then in fairness, I think you have to overturn the judgment against the kids, because they never would have been in that position if Myra hadn't been denied the discovery. And there's this one separate argument about what is the interest of a revocable beneficiary, which, as I've indicated to you, I think is a very complicated one to make in this situation. But they were taking a common sense approach. Hey, we're here, we think we have an interest, and if we're going to be bound by this and asked to be signed off on it, we'd like to see some documents. That's not a $50,000 penalty position to take. The last thing that I heard that I want you to be sensitive about is that it sounds to me, when you start undoing the Russian dolls and going back to 2016 and even 2014, I could not figure out any way from what Mr. Simu said that you can uphold his position without going back and making substantive decisions about what the things in 2014 meant and what the things in 2016 meant, which, as Mr. Simu indicated, aren't and shouldn't be final at this point. They're the subject of ongoing proceedings. And so it becomes virtually impossible for you to uphold Ms. Holt's position on this record. Now, maybe you can do what you suggested and say, we're even taking special action jurisdiction, and yeah, trustees are allowed to look at their accountant's files, grant some type of limited relief like that. But I don't think you can get very deep into this without causing all kinds of problems with the ongoing proceedings, looking into things that shouldn't be on appeal at this point. And that's the preclusive, the word that a lot of the cases use about 122102, the statute that says that you can review interlocutory orders once there's a judgment. Everything gets rolled up into a judgment. The word that they use in a lot of the cases is subsumed. It gets subsumed into the judgment. If you are going to subsume the 2016 ruling and those 2014 things, I don't think you can unsubsume them for purposes of the ongoing proceedings. We're going to end up with some kind of res judicata or collateral estoppel effects, and frankly, I'm going to be, or my colleagues are going to be down in the probate court taking the opposite position that I'm taking now, saying, oh no, that wasn't subsumed in the judgment, it's not preclusive against my client. It's a real can of worms, and that, frankly, is why Myra is here, because she doesn't know what she's precluded on if you get into the substance of these issues. We think we're right on the substance of the issues, but I would urge you to be very careful in the effects that you're going to have on particularly the 2014 issues, which are clearly still in front of the court, multiple pleadings, substantive issues about mistake, substantive issues about misrepresentation, execution.
And by the court, you mean the Superior Court, not
In the Superior Court.
Got it. Just wanted-
Yes, not before this court. Thank you, Your Honors. Oh, sure.
You're done with your argument?
I am done.
Because I have a legal trivia question to ask you. One of the most famous community property cases in Arizona is Baum versus Baum, involving a James R. Baum, who is not the same. That's all I wanted to know.
Thank you.
Counsel, thank you. You have given us much to think about. We will take this matter under advisement and issue a written ruling in due course. Thank you.